The morning I found the stump, I thought I was looking at a crime scene. Not a messy one. Not chaotic. Just wrong. Where a 200-year-old oak had stood for generations, there was now a flat, raw disk of pale wood bleeding sap into the dirt. The sawdust was still fresh. The air still smelled like chainsaw exhaust. And the sunlight, harsh and exposed, hit my porch in a way it never had before. That tree wasn't landscaping. It was history. It had been planted in 1824, according to family letters preserved in a cedar chest in our attic. My great-great-great-grandfather wrote about digging the hole by hand, about how the land was nothing but open field and stubborn clay, about planting the oak as a symbol that the family intended to stay. And we did. Through wars, through recessions, through fires and rebuilds. The house changed. The barn changed. The fences changed. The tree never did. It grew taller, whiter, stronger, and now it was gone. I didn't have to guess who did it. The week before, the HOA president had stood at the edge of my property line with a clipboard pressed against her chest like it was a badge. She'd smiled the kind of tight smile that doesn't reach the eyes. "It's a hazard," she'd said. "It's obstructing the uniform aesthetic of the community." The community was 5 years old. The tree was 2 centuries old. My property predates the HOA. By a lot. When the surrounding farmland was sold and carved into a gated development, I negotiated a limited covenant agreement so I could retain independent ownership while allowing shared road access. I pay a maintenance fee for the road. That's it. They don't own my land. They don't govern my land. They definitely don't get to touch my land. I told her that. She told me she'd review the documents. Apparently, her version of review involved hiring a landscaping crew at 7:30 in the morning while I was out of town for a 2-day business trip. They cut it clean. Professional. Efficient. Like they were removing a shrub. When I got home and saw it, I didn't yell. I didn't panic. I just stood there. Then I walked to the barn. Inside, mounted high in the rafters, was a weatherproof security camera system I installed after the subdivision went up. Not because I'm paranoid. Because I'm careful. The footage was crystal clear. A truck with the HOA's approved vendor logo backed up to my fence line. The HOA president herself stepped out. She pointed. They cut. She watched. She even took photos when it was done. I downloaded everything to 3 separate drives before I did anything else. Then I opened the cedar chest in the attic. Inside were brittle letters, hand-drawn land surveys, and an original 19th century deed with a wax seal. There were sepia photographs of the oak when it was barely taller than a man. Black and white portraits of family members standing beneath its branches. Wedding photos. Funeral gatherings. My father teaching me to fish in the shade of that canopy. You don't trim that. You don't remove that. You don't call it landscaping. You call it destruction. I called an arborist first. Not a lawyer. An arborist. He arrived the next morning, ran his hands across the rings of the stump, and went very quiet. "White oak," he said finally. "Based on diameter and growth pattern? Just over 2 centuries. Then he looked at me. This wasn't diseased. This wasn't dying. This was healthy. He paused. In some states, this qualifies as a heritage tree. I didn't need the legal term to know what that meant. I needed the valuation. He hesitated before giving it. With size, age, and replacement impossibility? He exhaled. You're not looking at thousands. He wrote a number on his clipboard. It had 6 zeros. That's when I called an attorney. And that's when things stopped being about a tree and started being about accountability. Because she didn't just cut down wood. She cut down documented, provable, appraised history. And she did it on camera. The HOA president thought she was enforcing landscaping standards. What she actually did was commit timber trespass on privately owned, historically documented property. By the end of that week, a certified demand letter was on its way to her office. And she still had no idea what was coming. The demand letter was polite. That was intentional. My attorney didn't threaten, didn't posture, didn't grandstand. He simply laid out facts. The oak tree was located entirely within my surveyed boundary. My property was not subject to landscaping authority under the HOA covenant. The tree had been removed without consent. The act constituted timber trespass and destruction of private property. Damages would be calculated based on replacement value, historical significance, and statutory multipliers. At the bottom, a number was listed, not a random one. A documented valuation prepared by a certified arborist using industry-standard appraisal methods for mature heritage trees. $412,000 base value. In our state, intentional timber trespass can be subject to treble damages. That brought potential liability to $1.2 million. The letter offered settlement at the base valuation if paid within 14 days. No publicity. No litigation. Quiet resolution. We even attached still images from the security footage, clear enough to count the teeth on the chainsaw blade. She responded in 48 hours. Not with a check. With defiance. Her attorney's reply claimed the HOA had reasonable authority to remove hazardous vegetation affecting community uniformity and safety. They argued the oak posed potential structural risk due to limb overhang toward the shared access road. That road is 30 feet from the tree. And the arborist had already documented 0 structural defects. They also made their first mistake. In their written response, they stated the board had voted unanimously to approve emergency removal. Unanimously. That word would matter later. Because my attorney filed a formal request for HOA board meeting minutes under the state's Property Association Transparency Statute. What we received was incomplete. There was no emergency vote. No arborist report. No hazard inspection. Instead, the minutes reflected a discussion about aesthetic inconsistencies between legacy parcels and community landscaping standards. Translation? They didn't like that my land didn't look like theirs. They wanted symmetry. And symmetry, apparently, required erasing 200 years of it. That's when my attorney shifted tone. The second letter was not polite. It included the full appraisal report, a sworn statement from the arborist confirming the tree's health, certified survey documentation proving clear boundary placement, time-stamped video stills showing the HOA president supervising removal, a demand for preservation of all internal HOA communications related to my property. That last part is crucial. When litigation is reasonably anticipated, destruction of records becomes spoliation. And spoliation makes judges very unhappy. The response time stretched this time. 10 days. Then 11. On day 12, I got a call not from her attorney, from a landscaping contractor, the same company that cut the tree. He sounded nervous. He said he'd been contacted by the HOA president again. She'd asked him to update the invoice to reflect that the removal was due to documented disease risk. He refused. He'd seen the footage too. He knew I had cameras. He also knew altering invoices after the fact could jeopardize his business license. He emailed me the original work order. It listed the reason for removal as client request aesthetic compliance. That email became Exhibit D. By the end of the month, we filed suit. The complaint included trespass, conversion of timber, property damage, and intentional misconduct. We also named her personally. Not just the HOA. Her. Because the footage showed her directing the removal beyond any formal vote authority. That detail mattered. A lot. Within 2 weeks of filing, something else surfaced. One of the junior HOA board members contacted my attorney confidentially. There had never been a unanimous vote. In fact, 2 members had objected. They warned her the tree predated the HOA and likely fell outside enforcement authority. She told them she'd handle it. She didn't call another vote. She didn't hire an independent arborist. She didn't consult legal counsel beforehand. She just ordered it cut. And she signed the contractor authorization personally, which meant this wasn't a board decision. It was hers. When discovery began, we requested internal emails. That's when the real problem for her appeared. Because in one message to another board member, she wrote, "If we let him keep that ridiculous tree, the entire perimeter loses visual cohesion." Visual cohesion. Not safety. Not hazard. Not emergency. Cohesion. That single email shifted the case from negligence to willful destruction. And under timber trespass statutes, willful intent triggers maximum penalties. Her insurance carrier was notified. They responded with a reservation of rights letter. Translation? They weren't sure they'd cover intentional acts. The HOA board called an emergency meeting. This time, it was actually unanimous. But not about landscaping. About distancing themselves from her. By the time mediation was scheduled, the number on the table was no longer $412,000. It was closer to 7 figures. And she was starting to realize this wasn't about a tree anymore. It was about proof. And I had all of it. Courtrooms are quieter than people expect. There's no dramatic music, no gasps, no shouting, just paperwork, fluorescent lighting, and long pauses that feel heavier than words. By the time our case reached the hearing stage, mediation had failed. She refused to admit intentional wrongdoing. Her position remained the same. She believed she had authority. Belief, however, is not the same thing as legal permission. The courtroom filled slowly that morning. A few HOA residents showed up, curious, nervous, whispering to each other. 2 board members avoided eye contact with her entirely. She sat beside her attorney, posture stiff, expression controlled. I sat beside mine, calm. Because calm people with documentation don't need theatrics. The judge began with procedural confirmations, then opening statements. Her attorney argued community safety, uniform enforcement, and discretionary authority granted under HOA governance provisions. He emphasized good faith decision-making. Good faith. That phrase would unravel quickly. When it was our turn, my attorney didn't speak emotionally. He started with the deed, a certified copy of the 19th century land patent, then the modern survey, then the covenant agreement clearly limiting HOA authority over my parcel to shared roadway maintenance only. He placed each document on the evidence screen, layer by layer. Jurisdiction first, then boundary, then limitation of authority.
Clean.
Methodical. The judge leaned forward slightly. Then came the arborist. He testified under oath that he had examined the stump within 24 hours of removal. He presented core sampling analysis and growth ring estimation. He confirmed the oak was structurally sound, disease-free, and not at risk of imminent failure. Her attorney attempted to question whether overhang toward the access road constituted hazard potential. The arborist didn't flinch. Any tree can hypothetically fall, he said. That does not make every tree hazardous. A faint smile appeared at the corner of the judge's mouth. Then we introduced the video. The courtroom lights dimmed. On screen, the timestamp glowed in the upper corner. 7:42 a.m. The contractor's truck pulled up. At 7:48 a.m., she stepped into frame. At 7:51 a.m., she pointed directly at the oak. At 8:02 a.m., the chainsaw started. There was no safety assessment, no emergency barricade, no urgency, just instruction. At one point, she crossed her arms and watched as the first major limb fell. The video ended with her taking photos of the stump. Silence filled the room when the lights came back on. Her attorney pivoted. He argued she acted in reliance on board consensus. That's when my attorney introduced the meeting minutes. Incomplete ones. And then the corrected testimony from 2 board members who had provided sworn affidavits. They confirmed no unanimous vote occurred. They confirmed objections were raised. They confirmed she said she would take care of it personally. The judge turned toward her. Did you obtain an independent arborist evaluation prior to removal? No, Your Honor. Did you seek legal counsel before authorizing destruction of a 200-year-old tree on a parcel not governed by your landscaping authority? No, Your Honor. Did you review the original covenant limitations? I believed I understood them. Belief again. Then came the email, projected onto the screen. If we let him keep that ridiculous tree, the entire perimeter loses visual cohesion. The judge read it silently first, then aloud. Visual cohesion. He set his glasses down. Counsel, please clarify how visual cohesion constitutes emergency hazard mitigation. Her attorney hesitated. He shifted to arguing community standards enforcement. The judge interrupted gently. Community standards do not supersede private property ownership outside covenant authority. That sentence changed everything. Because now the framing wasn't negligence. It was overreach. Intentional overreach. Next came damages. The arborist explained valuation methodology, trunk formula method, species desirability, age multiplier, historical documentation, irreplaceability factor. He detailed how replacement cost for a tree of that maturity is not literal replanting, but compensatory valuation for loss of ecological and historical asset. Base value, $412,000. Then my attorney cited the state's timber trespass statute. Intentional removal permits treble damages. The judge asked one final question directly to her. Did you understand this tree predated the HOA? Yes. And you removed it anyway?
She paused.
Yes. That was it. No more debate about hazard. No more debate about confusion. It was acknowledgement. Intent. The judge announced he would take the matter under advisement and issue a written ruling. As we stood to leave, I glanced once at the empty space outside the courtroom window where branches used to cast shade across my porch. For the first time since the chainsaw started, I felt something shift. Not anger, not grief, resolution. Because once intent is established, consequences follow. And in this case, the statute was very clear. The ruling came 3 weeks later. 22 pages.
Precise.
Structured. Unemotional. Devastating. The judge began by outlining jurisdictional boundaries. He reaffirmed that my parcel was not subject to landscaping governance under the HOA's recorded covenants. The only authority granted to the association involved shared roadway maintenance and limited utility easements. Landscaping control? Explicitly excluded. That alone dismantled her primary defense. Then he addressed intent. He cited the security footage, the sworn testimony of 2 board members, and, most critically, the internal email referencing visual cohesion. In his words, the defendant acted knowingly and without lawful authority when directing the removal of a 200-year-old oak located entirely within the plaintiff's privately held parcel. Knowingly, without lawful authority. That phrasing triggered the state's timber trespass statute, which meant enhanced damages applied. The court accepted the arborist's valuation methodology in full. The defense had attempted to argue depreciation, speculative historical valuation, and sentimental inflation. The judge rejected all 3. He wrote, "The loss of a heritage white oak of documented age exceeding 2 centuries constitutes measurable economic damage beyond ornamental landscaping value. Base damages, $412,000. Then came the multiplier. Treble damages for intentional timber trespass, $1,236,000. The courtroom had been quiet during hearings. It wasn't quiet when the ruling circulated. But the judge wasn't finished. He addressed personal liability. Her attorney had tried to shield her behind the HOA entity, arguing she acted in official capacity. The judge disagreed, because she had failed to obtain formal board authorization, ignored objections from fellow board members, signed contractor approval individually, acted outside covenant authority. Those elements pierced the liability shield. The judgment specified joint and several liability between her and the HOA, but allocated primary responsibility to her personally for willful misconduct. Translation? Her homeowner's insurance wouldn't automatically cover it. And the HOA's policy had already issued a reservation of rights regarding intentional acts. Within days, the HOA board convened another emergency meeting. This one wasn't about landscaping. It was about survival. Legal fees alone had already exceeded 6 figures. Insurance counsel warned that coverage denial was likely. If the association paid the full judgment from reserves, special assessments would follow. And no homeowner in that development wanted a surprise 5-figure bill because their president couldn't tolerate visual asymmetry. She resigned 2 days later. Publicly, she cited personal reasons. Privately, residents were furious. Two board members who had objected initially testified again during post-judgment proceedings regarding indemnification. They made it clear she had overridden internal caution. The HOA voted to pursue reimbursement from her directly for any uncovered portion paid by the association, which meant she wasn't just facing a $1.2 million judgment. She was facing potential internal litigation. Her attorney filed a motion to reduce damages. It failed. The judge reaffirmed statutory treble application due to clear acknowledgement of intent. He added one more sentence that spread quickly through local legal circles. Aesthetic preference does not authorize destruction of documented history. Collection proceedings began. Liens were filed. Assets were evaluated. Settlement discussions reopened, but now from a very different position. Within 60 days, a structured payment agreement was reached. Confidential terms, but the headline number remained public record. Over $1 million. All because she believed authority meant control. Meanwhile, something unexpected happened. Local historical preservation groups contacted me. They'd heard about the ruling. They asked for copies of the old photographs and letters documenting the oak's age. One organization offered to place a small commemorative marker near the stump, recognizing the site as a heritage landmark lost to unlawful removal. I agreed. Not because it replaced the tree. Nothing could. But because documentation mattered. Memory mattered. And precedent mattered. Neighbors who once avoided eye contact started stopping by. Some apologized quietly. Others admitted they'd assumed the HOA had more power than it actually did. That assumption cost their former president over $1 million. But it also clarified something important. HOAs operate within boundaries. And when those boundaries are crossed intentionally, the law responds. The oak was gone. The shade was gone. But the accountability? That was permanent. The stump is still there. I could have had it ground down, removed,
Erased.
but I didn't. Instead, I sealed it. A preservation specialist treated the exposed rings so they wouldn't rot or split. Now the cross-section sits smooth and protected, each growth ring visible like a timeline carved in wood. 200 years of seasons.
Droughts.
Storms. Winters. Springs. You can count them with your fingers. A small bronze plaque now stands beside it. It doesn't mention lawsuits. It doesn't mention money. It simply reads, White Oak, planted 1824. Removed 2025. Preserved in record and law. The Historical Preservation Group kept their word. They archived the family letters and photographs digitally. A local university forestry department even requested permission to document the case study for legal and environmental coursework. Because this wasn't just about property law. It became a textbook example of statutory timber trespass enforcement tied to documented heritage valuation. The HOA changed too. Not overnight, but significantly. 3 board members stepped down within 6 months. New elections were held. The revised bylaws now require independent expert review before any vegetation removal dispute, mandatory legal consultation for actions involving parcels with limited covenant authority, recorded supermajority vote for any enforcement beyond routine maintenance, transparent member notification before contractor engagement. In other words, process. The development's landscaping still looks uniform, but it also looks careful, measured, less eager to erase what predates it. As for her, the financial impact was substantial. The structured judgment payments required asset liquidation. I won't pretend to know every detail, but public records showed refinancing, property transfers, and the eventual sale of her home within the development she once governed. There was no dramatic confrontation, no apology, just consequences unfolding quietly over time. People sometimes ask if the money made it worth it.
No.
You don't replace 200 years with a wire transfer. But what the judgment did restore was boundary. It restored the principle that authority has limits, that documentation matters, that confidence without jurisdiction is just trespass dressed up in policy language. I planted something new this spring. Not another oak. That wouldn't be honest. You can't recreate 2 centuries. Instead, I planted a young white oak sapling about 20 feet from the original site.
Smaller.
Fragile. Staked upright against the wind. It won't reach maturity in my lifetime. But that's not the point. The original oak was planted by someone who knew he wouldn't sit beneath its full canopy either. He planted it anyway. That's what legacy is. Not control. Not uniformity. Not cohesion.
Time.
The court ruling didn't just award damages. It set precedent locally that HOA enforcement cannot override recorded property rights simply because something looks out of place. And that matters beyond my land. Since the case closed, I've received messages from homeowners across the state dealing with aggressive boards, overreaching precedents, and vague covenant interpretations. My advice is always the same. Read your documents. Know your boundaries. Install cameras. And never confuse confidence with authority. The tree is gone. But every time sunlight hits that preserved stump, it reflects off the bronze plaque and reminds anyone walking past. History doesn't disappear quietly. And neither does accountability. The HOA president cut down a 200-year-old family tree. The judge made her pay over $1 million. But the real lesson wasn't about money. It was about limits. And limits, once enforced, grow stronger than any oak ever could.